Some important laws that apply to autism are Section 504, the Americans with Disabilities Act, and the Individuals with Disabilities Education Act. The first of these is Section 504 of the Rehabilitation Act. Section 504 is just one sentence long, but is regarded as the first disability civil rights law in the U.S. because it addresses discrimination. It was a foot in the door towards getting disability accommodations. Basically, it states that any program receiving federal funds can't discriminate against disabled people for any reason whatsoever. The text of 504 states, "No otherwise qualified individual with a disability, in the United States, as defined in Section 70520 of this title, shall, solely by reason of her or his disability, be excluded from the participation in, be denied the benefits of, or be subjected to discrimination, under any program or activity receiving federal financial assistance, or under any program or activity conducted by any executive agency, or by the United States Postal Service." But to get the regulations around 504 signed, 150 disabled folks had to occupy the San Francisco Federal Building for 28 days, which made it the largest sit-in in U.S. history. I love this short but really cool enactment of this, the 504 sit-in by Drunk History. Click on the link below as it gives you an idea of what it takes. I also highly recommend watching the Netflix movie Crip Camp, which was nominated for an Oscar. There is a difference when it comes to civil rights for race and gender versus when it comes to disability. I heard this difference explained really nicely by Arlene Mayerson, who is the directing attorney of Disability Rights Education and Defense Fund. Civil rights for race and gender is about treating everyone the same. For example, you take away the sign that says that blacks could only sit at the back of the bus. Civil rights for race and gender is about treating everyone the same. For example, you take away the sign that says that blacks could only sit at the back of the bus. Section 504 only addressed areas that received federal funding. The Americans with Disabilities Act extended it to other areas. All the different titles looked at different areas. Again, there were a lot of delays in getting it passed. In March of 1990, over 1,000 people protested, and 60 disabled people cast aside their wheelchairs and crawled up the steps of the Capitol Hill as a physical demonstration to show how inaccessible it was to them. The highly televised Capitol Crawl, as it came to be known, was the impetus behind getting the Americans with Disabilities Act signed into law that September. The youngest crawler, Jennifer Keelan Chaffins, was just 8 years old, and there is a children's book about her called All the Way to the Top. The Americans with Disabilities Act has been more successful where the changes are tangible and visible. For example, changes in the built environment, like ramps and accessible transportation, are easier to catch and implement. Incidentally, the city of Berkeley was the first city to voluntarily put curb cuts on street corners, long before the Americans with Disabilities Act mandated it. Another example is closed captioning. Harvard was sued in 2015 by the National Association of Deaf, as many universities including MIT and Berkeley had chosen to pull down their online video content, rather than spend money on captioning as required by the Americans with Disabilities Act. They claimed it imposed undue hardship. Netflix was also sued in 2011. That's why you see closed captioning in most media now. Where there has been less success is in areas like employment. I feel this is due to the rather fuzzy language around accommodations. A key principle around accommodations is providing reasonable accommodations to the disabled person without undue hardship to the employer, providing them. Both undue hardship and reasonable accommodations can be argued. What is the extent of undue hardship for a company? What is the extent of what can be considered to be reasonable accommodations for the disabled individual? In addition, the Act does not properly address changing technology needs, healthcare, community support services, and aging services. Another issue is that there is no penalty for entities that fail to follow the regulations of the Americans with Disabilities Act. The only way to redress violations is through lawsuits. That raises the question, how many disabled people have the time, money, effort and resources to keep suing? As it is, many disabled people are living in poverty. The Act is also thought to be not intersectional enough, that it was geared toward the white disabled man. The Act was not intentionally written that way. Society just makes it harder for marginalized groups to access laws that is supposed to be helping them. To give you context, Judy Heumann is quite the legendary disability civil rights leader and well known in the disability community. She is the one who led the 504 sit-in. If you are interested in disability civil rights and the disability rights movement, this book is a fantastic read. When trying to understand equality and accommodations, this really stood out from Judy's 2020 recent memoir. Part of the problem is that we tend to think that equality is about treating everyone the same, when it's not. It's about fairness. It's about equity of access. And equity of access looks different for me. When this is not understood, we get framed as complaining, even though we are asking for the same rights as everyone else. When this is not understood, we get framed as complaining, even though we are asking for the same rights as everyone else. In my undergraduate disabilities studies class, we discussed accommodations for the more traditional disabilities. A critical issue for traditional disabilities is removal of architectural access barriers. Removal of architectural barriers face a lot of resistance due to the perceived initial high dollar cost to implement. However, it's an uniform application for the most part in that it is tangible and concrete in terms of what needs to be done. But what do accommodations even look like for autistics? Accommodations are going to be nebulous in terms of uniformity of application, as each person is unique in their level of support needs. There could even be clashing accommodations for two different people. Everyone is not calmed down by the same thing, and some things can make it worse. For instance, dim lighting works for some while others need bright lighting. So which needs get priority? And who gets to decide this? This is really the conversation for our generation to work on. I personally think this is one of the biggest barriers to employment for autistics. I can see employers wanting some minimal predictability, and not want to reinvent the accommodations wheel for each new autistic they employ. Or employers may employ only a certain profile of autistics who fit into their idea of what minimum accommodations they think they can provide. Remember, the law also talks about undue hardship to employers, and that accommodations have to be reasonable. So many autistics may be considered unemployable as they are perceived to cause more undue hardship to employers. All this means is that we will not really have solved the employment problem for a majority of the autistics. This is very concerning. Before laws like IDEA came along, the alternative was institutionalization if you were considered to have high support needs. IDEA is the reason why many autistics like me were able to attend college. It's not perfect, but it's a great start. IDEA stipulates the right to a free and appropriate public education in the least restrictive environment. There are 6 basic principles to IDEA. FAP translates roughly to a free education in public schools, with support such as various therapies, support staff and other services that may be required whether the student is in special education or regular education. LRE means disabled students should be included in mainstream classrooms with neurotypical kids as much as possible. A better classroom placement can make a huge difference to an autistic child's progress. My experience has been that severe autism classrooms are just babysitting with zero expectations. Districts try to get around LRE requirement by showing recess and lunchtime as mainstreaming time, but still segregating disabled students the rest of the time in special education classrooms. Somehow being around other typical kids in a crazy noisy recess playground was supposed to help you absorb skills through osmosis or something. Exactly what constitutes FAP and LRE for each kid is decided at meetings between parents and the school district to produce an individual education plan. This is where conflicts arise, as districts are often guided by resource constraints and other factors and not necessarily by what is most appropriate for the child. Both sides are supposed to be working together to advance the interests of the child but end up as antagonists. Case law says districts need only provide a working car and not a Cadillac. But what comprises a working car is fuzzy logic. Evaluations refers to periodic testing to check progress and fine-tune educational settings. I had to undergo this huge battery of tests every 3 years, which really were quite exhausting. I really hated any such testing, as I did not see any point. It's not like I was moved to a better classroom or got more services. It was like a rinse-repeat exercise. And the reports pretty much were a list of everything I could not do, almost like the school was using this to justify why I should not be moved to a better classroom. Procedural safeguards basically means the right to sue. In fact, during the COVID pandemic, parents in some states had been asked to sign away this right in order for their kids to get services. You may come across something called a 504 plan. A 504 plan accommodates students who can learn in the general ed environment with some modifications. IEP, on the other hand, provides specialized supports that a 504 does not. The point is that laws like this are necessary, though they are a work in progress, as a lot more goes into what makes up a fair and inclusive society. IDEA enables access to education via accommodations. It is one thing that it is such a fight to get accommodations and services from school district. But what is troubling is how the system is also gammed. Some parents may even push for a disability diagnosis to get more support and services, as it feel it gives an edge for their kids, like individualized learning, smaller classes and extra testing time, etc. In 2019 we saw how wealthy people gammed the system in the Operation Varsity Blues college admissions scandal. Celebrities like Lori Loughlin paid for her child to get a cognitive disability diagnosis that granted her extra time and a private room for her SAT exams. As a disabled person, I was super annoyed. Getting the right set of accommodations in place in order to enable access to the basic educational system is usually a hard-fought-for battle throughout one's life, and it's downright annoying to see those who do not even have a disability waltz in and misuse it. Such misuse discredits the need and value of such accommodations for disabled community. It also adds to the stigma around disability accommodations. This slide outlines what the education system under IDEA roughly looks like at different ages. Ages 0 to 3 is called Early Intervention or Early Start programs. In the state of California, the regional centers under the Department of Developmental Services are usually in charge of all programming at this age. From age 3 onwards it falls to the public school district. This can mean education in a special education classroom, a mainstream classroom, or a combination of both. It also includes all the supports and services needed to help the child succeed. Special education can mean classrooms that are housed in the public schools itself, or in private special education-only schools. Depending on how the special education is structured, there can be a lot of interaction with non-disabled peers, or it can be an isolating experience. Around middle school, between ages 14 to 16, is the transition plan into two distinct branches. First is the academic track through high school ends with a high school diploma. This is the path similar to what most neurotypical students will take, except that under IDEA, the autistic student will get appropriate accommodations and other services to ensure access. The autistic then has the same opportunity as the non-disabled individuals to go on to college once they get the high school diploma. The non-diploma track is supposed to be a vocational track, which leads to certificate of completion at age 18. A majority of autistics tend to get pushed towards the certificate of completion track. This is supposed to be a life skills track, where they are supposed to be learning other useful skills. And in order to give an equivalent to the 4 years of that non-disabled kid's student's experience, this track is offered 4 years of a post-secondary program from ages 18 to 22. The post-secondary program is again supposed to teach them job skills or other useful life skills. Many secondary programs are basically a continuation of special education for the most part, and most students remain in their special education placements. Some universities have started offering a 4-year non-degree track on their campus itself. The idea is that you can take part in all the extracurricular life and audit select courses, but for the most part you have your own programming. For the diploma track, IDEA protections end as soon as they receive their high school diploma. For the certificate track, IDEA protections end at age 22, at which point they exit the school system into the adult world. Age 22 is also called the services cliff, as the number of services sees a drastic reduction all of a sudden. Thank you.